we are going to continue with our yesterday's discussion. And if we have time left, we would move on to another concept called federalism. I hope you got time to at least go through some of the portions of the article that was circulated. We are not going to discuss the article completely. Just going to pick up few points from those articles because Jeremy Walden's article on constitutionalism itself is sort of questioning whether the manner in which we use the term constitutionalism is in itself correct or not. Yesterday we were discussing this difference between constitution and constitutionalism. Now one of the most popular meanings and the term constitutionalism is used rather vaguely, but one of the most popular meanings that has been assigned to constitutionalism is that it is a form of limitation of the government. So that is one of the most popular meanings. And all the principles that limit the government are a part of constitutionalism. Now, constitutionalism is an idea, can have two different aspects. One is obviously the static aspect, and the one is the variable aspect. Now, when I say constitutionalism as a philosophy or as an idea may have a static concept, I mean to say that now most of the constitution across the globe will have some kind of commonality. They will if you do an empirical study of the constitutions across the globe, what you will find is that there is a kind of commonality and there are some principles that are considered to be intrinsic to each and every of those constitutions. Let's say, for example, separation of power, or let's say, for example, perhaps rule of law. All these are sort of some of the basic principles which have been considered almost across the globe. Almost all the constitution does have this principle. Now that is a static, not the static part, but rather the common part of this idea. Common would be more appropriate term here. The common part of the idea of constitutionalism. And then there is also the the variable aspect of constitutionalism, wherein every specific constitution will have its own understanding of what is constitutionalism, meaning its own understanding of what are the principles that it is invoking according to the popular meaning of constitutionalism to limit the government. Now, for example, United Kingdom may have this idea of parliamentary sovereignty as something that they hold very dear, but the same may not may not be true for United States or United Kingdom, wherein parliamentary sovereignty, United States or India, wherein parliamentary sovereignty has not been accepted to be a part of a constitution. Now, what I mean by parliamentary sovereignty is that when the parliament passes a law, the scope of judicial review of that law is very limited. So judiciary, once the law is what the parliament says. So the supreme arbitrator of what the law is what the parliament says. That is not specifically true in countries that follow a very strong system of judicial review, like United States, wherein judicial review was introduced through Marbury versus Madison, when the Supreme Court of US said that the Supreme Court, the judiciary, especially the Supreme Court, has the power to review the constitutionality of the laws made by the legislative wing of the government. The same goes for India as well. So in India, for example, when we saw a shift from procedure established by law to due process of law in the 1960s onwards, under Article 21 of the Constitution, we found that this power of judicial review strengthened. And the idea of parliamentary sovereignty in so many of the judgments has been considered not to be a part of Indian idea of constitution. So that is what I meant to say, that constitutionalism as a concept or as a principle or as a theory may have some common features, general features which may be common to many constitutions or common to almost all the constitutions across the globe, but they may also have some particular, specific or variable feature which can be found only in specific constitutions. Now, But more or less, what constitutionalism means is a set of principles in the popular terminology which are invoked to limit the government. Okay. That is what the idea of constitutionalism is. That does not mean that that is the only definition of constitution prevalent. There are several other definitions of constitutionalism which are floated and which try to expand or constrict the content of what is it actually that forms the constitutionalism. Now, the second aspect of constitutionalism, as I mentioned it to you yesterday, was that in order to have constitutionalism, it is not necessary to have a constitution. Because constitutionalism is not about having a written or an unwritten constitution. Constitutionalism is about certain principles which are invoked to limit the government. That is what constitutionalism is about. So that's why yesterday we were discussing there is a possibility that you may have a constitution without having constitutionalism. Now, one of the examples that is generally given is China, wherein China does boast of a constitution, but most of the provisions of Chinese constitutions are hardly applicable. Judiciary does not have the power of review, and despite having a constitution, the idea of constitutionalism is found to be lacking by constitutional law theorists in China. So, and that can be possible for several other countries where you may have a constitution, but you do not use the constitution to sort of circumvent the principles of constitutionalism itself. So having a constitution is no guarantee of having constitutionalism, and that is where a distinction is drawn between these two concepts. And the opposite may also be true. You may very well have constitutionalism without having any formal constitution. And by formal constitution, I mean both written or unwritten constitution. Though written constitutions are more popular, if you look at countries, most of the countries have written constitution, except perhaps United Kingdom. But again, constitutionalism may very well exist independent of a constitution, whether written or unwritten. And similarly, having a constitution, formal constitution, is no guarantee for constitutionalism. And that is where these two principles bifurcate or are disjunctive. That's why constitutionalism is not about formal constitution. Constitutionalism is about a set of principles that are invoked to limit the government in the popular sense. Now, if you look at Jeremy Walden's, okay, there is a question. Okay, Dinesh. Not necessarily. That's why I told you constitutionalism as a philosophy or as an ideology may have certain general principles which are common across the constitutions across the globe. And there are certain principles which, as you yourself are mentioning, are particular to time and society. So that's why I gave you the example of parliamentary sovereignty. For example, if you ask a British constitutional law student to define what are the principles that are intrinsic part of British constitutionalism, parliamentary sovereignty may be one of them. But if you asked an Indian constitutional law student to define or to what are the intrinsic features of Indian constitution, you will not find a mention of parliamentary sovereignty. But you will find a mention of rule of law, separation of power as a part of constitutionalism in both these countries. So that's why there are certain common or general features of constitutionalism which are common to almost all the constitutions across the globe, and then there are certain particular features of constitutionalism. So the content is not defined, but you can still cull out, if you try, certain general principles or doctrines or concepts which form a part of this idea of constitutionalism. I hope the question was answered, Dinesh. So that is where we are. So that is how you need to understand constitutionalism. That again, first of all, that it can exist independent of constitution. It is not necessarily dependent on having a formal constitution. And secondly, that there may be certain general principles of constitution, but also some particular principles of constitutionalism. Now that is all that you need to know, at least at this level, about constitutionalism, because otherwise the discussion on constitutionalism itself may take one semester. That's how rich literature is on this idea of constitutionalism. But we will confine ourselves to to what we have discussed till now, and maybe invoke Walden's article subsequently during the course of our discussion and discuss more on constitutionalism. Now, before I move on to, Pooja, that's a popular meaning which is assigned to constitutionalism, that constitutionalism talks about limitation on power of the government. That is the popular meaning. And that is not the only definition that we subscribe to when we are talking about constitutionalism. Many would argue that constitutionalism is not just about limiting the power of the government, but also limiting power per se. Many would argue that. The reason I'm just invoking limitation on power of the government is because that is the popular definition that seems to doing the round. That seems to go around. So, but that, just to clarify the position, if it was confusing, that does not mean that is the only definition. But the popular one being constitution being a limitation. Constitutionalism is about those principles that limit the power of the government. By explicit constitution is Ravikant, can you explain what you mean by? Do you mean explicit as in written and implicit as in unwritten? Just please try to explain that. Another question by Vinay. There is some commonality in constitutionalism across groups. So can we say those principles are basic? Yes, Vinay, we do say that. That those common principles are basic principles, are principles which form the core of constitutionalism. So yes, we can say that. Ravikant, so try not to use, first of all, explicit and implicit, because that is not the terminology that we generally invoke, though what we are saying still becomes clear by using explicit and implicit, but it would be better if you use written and unwritten. So, yes, written constitutions are obviously way better when it comes to locating those principles which are enunciated by the Constitution. It does sort of provide a kind of a definity to what the Constitution is about, but and it is more accessible to people at large, because they need not necessarily be trained in law to understand the idea of precedent, etc., etc. Having said so, that does not mean that unwritten constitutions are not workable. We have United Kingdom as a workable model of unwritten constitution. But yes, written constitutions become are more and that is the reason why written constitutions are more popular, because it becomes easier to find constitutional principles and maybe interpret them, or provide boundaries of what the Constitution is about. So yes, you are correct in that regard. Will Constitution also limit individual citizens by the values and principles it sets forth? Yes, it does, Runjun. Constitution does limit not only the state but also individuals. That's why I gave you the example yesterday when I was saying that Constitution is a limitation on power. Why is it a limitation on power? Because it does limit the power of the individuals as well. For example, let's take the example of Article 17, prohibition of untouchability and declaration of untouchability and offence. India is the only constitution in the world that declares something to be an offence in the constitution itself. Generally, declaration of offence is left to penal statutes, but India declares. What India does is that it declares an offence in the constitution itself. So, yes, constitution not only limits the state, but it also limits individuals. If not directly, then indirectly, because the state is allowed only to frame laws that adhere to constitutional values. Now, the laws are meant to control or regulate citizens. Now, that means that the laws that are regulating citizens have to be in conformity with the Constitution. That is an indirect application of constitutional values, but we also find application of direct application of constitutional values in the Constitution. For example, under Article 17 or under Article 23, which declares begar to be an offence, very similar to Article 17, which declares untouchability to be an offence. Okay, now there is another question. Give me 1 second. Difference between limiting power of government, restraining the government, and controlling the government. Okay. Now, the question of Basant is specifically addressed, is in the context of Jeremy Walden's article, wherein he's trying to distinguish between control, restraint, and limiting the power of the state. Now, what Jeremy Walden says, and this you can find on page 13 of the article that I circulated. Maybe you can open it so that you can have a better idea of what we are discussing. I hope that is the context in which you are asking Basant, in context of the Walden's article, where he is distinguishing between the term limiting, restraint, and controlling. And that is how I've understood your question to be. Now, if you look at the first paragraph of first part of paragraph of 7th segment of Walden's article, he says that that constitutionalism is not just a normative theory about forms and procedures of government. It is also about controlling, limiting, and restraining the power of the state. That this is about controlling the state, power of the state, limiting the power of the state, and restraining the power of the state. Now, subsequently, what he does is that he goes on to distinguish between the three terms, that is restraining, limiting, or controlling. Now, when he says control, according to him, controlling a state is different from restraining a state. The reason being that when you say that you control a state, and this is Walden's interpretation, you are not giving it a negative connotation. So, and that is where he gives an example of someone driving a car. So when someone is driving a car or controlling a car, you are not just saying where you will not go. That is a negative connotation, but you are also determining where the car will go. That is a positive connotation. Okay. So according to Walden, the idea of control has both positive and negative connotation, and it is not necessarily a negative connotation. And then it is not just about what the government cannot do, but also about what the government can do. Okay, that is what control means according to Walden. So, and therefore Walden goes on and says that if, let's say, if we the people want to control the government, then they will not just tell us what is it that the government cannot do, but what is it also that they have to do. That is what is meant by control, the term control. Okay, that is what Walden says. And we are not talking about controlling the government. Walden is initially just discussing about these three terms. Control. Control, according to Walden, has both negative and positive connotation, wherein it is not just about what someone cannot do, but also what someone can do. The second is restraint. Now, restraint, according to Walden, is a negative idea, which says that what is it that someone cannot do. Okay, so it is only a negative connotation. Now, if a restraint is coupled with a positive connotation, it will cease to be a restraint according to Walden and will become a control. Now, let's say if you are only allowed to decide where the car cannot go, then you are restrained by that principle. You are not controlled. You are restrained by that principle. You are not controlled by that principle. So that is the meaning of restraint according to Walden. Now, what Walden seems to say is that when we talk about limitation and limiting the government, what we are talking about is the idea of laissez-faire constitutionalism. Now, if you are aware, laissez-faire idea is an idea which is very typical to libertarians or classical liberals, which says that there must be minimum state intervention. And according to Walden, when we are talking about when we are talking about limitation, we are talking about a form of, in a broader sense, about limiting the government and following the idea of laissez-faire constitutionalism. So that is how he tries to differentiate between these three terms first, that is control, limitation, and restraint. And he has a problem with usage of these terms and in an interchangeable manner. And what he says is that what we do, or what many of the constitutionalists do, is that they generally use all these three terms in a limited fashion, and in a manner which is not per se appropriate when you are discussing constitutional law debates. So that is how he understands control, restraint, and limited government. If that clarified your question, Vasant. If not, maybe I can elaborate it further. So the reason why Walden is discussing it is so that we do not use these terms interchangeably. There is a certain connotation to all these three terms. Okay. In case anyone has any confusion on the description of these three terms, just let me know again. Okay. What does limiting mean again? Let me see how I can explain it. Now, let us so just understand that the discussion that we are having is in the context of Walden's article on constitutionalism. This may not be the accepted definition everywhere, because Walden is just laying open questions for us. If you look at Walden's article, it ends with a question. So he's just laying open questions for us. Now, I will just take you to the text of that article so that you understand what Walden means by, when he's talking about limited government, what is it that he actually means. Now, he says that constitutionalists talk of limited government, and they mean not just the avoidance of particular abuses, but a broader sense that many of the aspirations that government protect, particularly democratic government, have sometimes had are per se illegitimate. Those who set up a democracy may be hoping for government intervention to ameliorate poverty, promote public health, and protect the environment. But now, and they may face opposition from opponents. But now it seems that these opponents can phrase their opposition not just directly as a political position, but also they can take on mantle of constitutionalism and add to their case against intervention, that interventionists do not take the constitutional dimension of governance seriously enough. With this sense of limitation, constitutionalism forfeits any claim to political neutrality. It is associated instead with conservative criticism of big government. Right? Now, what he says is that the problem, and so first let me just explain it to you, clarify in the very beginning, the reason why Jeremy Walden in his article is trying to differentiate between control, limitation, and restraint is because he has a problem with these terms being used interchangeably and the manner in which these terms are used. Now, what he says is that at least in the United States, limiting the power of government is closely associated with laissez-faire constitutionalism, wherein you do not want the government to move beyond the laissez-faire model. Now, those who are not aware of the laissez-faire model basically is a free market idea model, which is that forms the core ideology of libertarians or classical liberals, who say that the market forces should do most of the governance, and state should take a backseat and must interfere minimally. There must be minimal intervention of the state. So, the state is not allowed to regulate the marketplace. Rather, the state is only going to minimally intervene in the market. So it is a laissez-faire model, something which you may read about in Adam Smith's Wealth of Nations and in all the classic liberals when they talk about it, that minimal intervention of the state. Now, when we say minimal intervention of the state, we just cast a negative obligation on the state that the state should not do. So when we are talking about limiting the state from a laissez-faire perspective, we are only talking about what the state cannot do. We are not talking about what the state can do. Okay. Now, Let me explain to you, for example, take an indigenous example and maybe that will become clearer to you. Let's take the example of Indian Constitution. There is part 3 of the Indian Constitution, which is fundamental rights, and part 4 of the Indian Constitution, which is directive principles of state policy. Now, a majority of the rights mentioned under part 3 of the Constitution are negative rights. When I say negative right, it means it casts a negative obligation on the state. And the state shall not interfere in the freedom of speech and expression. It is not necessary that the state will go ahead and encourage people to speak and express themselves. That is not the function of the state, or that is not the obligation which is cast on the state. So the state tomorrow cannot come to me and say that, okay, you must let us encourage everyone to speak. Please, is not expected to do that, to speak freely or express themselves freely. What the state is supposed to, the obligation, the primary obligation under Article 19(1)(a) is that the state is not going to interfere in the exercise of freedom of speech and expression of any individual. Okay, that is negative obligation. So it is about the state not doing anything. Okay, the state not interfering in your rights. Now, laissez-faire model of constitutionalism basically talks about such negative kind of limitations of the state, whether they are in the form of human rights or whether they are in other forms, that the state shall not intervene. Now, when you cast positive obligations on the state, you basically tell the state that the state is supposed to do something. So, for example, directive principles of state policies, part 4 of the Constitution, are primarily a set of positive obligations cast on the state. So, it says that there must be equal pay for equal work. And that there must protection of environment is important, etc., etc. So what you are, there must be free legal aid, Article 39(a). Now, what is being said here is that an obligation is being cast on the state, that the state has to do something. For example, affirmative action. It is not saying that the state shall not discriminate, but rather state shall also take positive steps and positive measures to ensure that there is no discrimination perpetuated in the society, right? By ruling affirmative action. So what it means is that when we are talking and the criticism of Jeremy Walden against those who talk about constitutionalism as limiting government is that most of those who talk about constitutionalism as a limitation on the power of the government are only giving it this negative connotation. They are not at all bothered about the positive connotation, right? Their focus is on what the state cannot do, not on what the state should do. Now, once the focus of this idea of limiting the government becomes something that the state cannot do, what you are basically doing is that you are just following the same classical liberal ideology. You are following the ideology of laissez-faire model. And then Jeremy Walden has a problem with it because he says that is the point where the constitutionalism as limitation on the power of government loses all its neutrality, because it becomes nothing but a mouthpiece for classical liberalism or laissez-faire model of constitution. And that is what Jeremy Walden has a problem with. The only reason, and you have to understand in the context of article, because I understand that is why Basant posed this question, and the only reason Walden is trying to differentiate between these three terminologies is because of the usage, the manner in which they are used. So according to Walden, he has a problem with the usage of the terminology limiting the power of the government, because most of the time this terminology is used to cast negative obligation or argue for negative obligations of the state and not for positive obligations of the state. And we have found that most of the constitutions, even constitutions in the United States, which was the hub of which is considered in the modern era to be the hub of classical liberal ideology, has now it does not strictly follow the classical liberal ideology, and it does argue for not just state having negative obligation, but state also having positive obligation. Now, that is the main difference between Republicans and Democrats in the United States, wherein so everyone is a liberal, but Republicans are libertarians or classical liberals, and Democrats are the are the other version of liberalism, wherein we argue for positive obligation on the state and not just negative obligation on the state. Yeah, I hope the question was answered, Pratishtha. If not, I will explain it to you again. Okay. Fine. So now, so as I was saying that I think this much introduction or this much idea of constitutionalism would suffice for the time being. We would obviously be invoking this idea again and again during the course of our lecture. So that would be done in due course of time. Now, before I shift to other topic which I was planning to, I would just like to introduce another concept to you. Not because it is a part of your syllabus, it is not. You will not even be reading about it in this, at least in your constitutional law course, 1 and 2 both. But I would like to introduce this idea to you because it sort of deals with an overlap between international law and constitutional law. And you have already studied public international law. And many of you, generally in the initial stages of studying public international law, have this question in your mind that what is the relevance of public international law? There is much more relevance as more than we comprehend. Now, and there is an area where constitutional law and international law merge, and which is a very recent development in the constitutional law discourse. That is the idea of transnational constitutionalism. Now, many of you would think, what is exactly transnational constitutionalism? Transnational constitutionalism is okay. Before I move to transnational constitutionalism, let me just first take you back one semester and discuss the relationship between international law and municipal law. Now, when you studied relationship between international law and municipal law, you studied that it is not that municipal law and international law operate in completely different spheres. There is a constant interaction that goes on between them. And you studied several judgments to that effect, wherein Indian courts, and Indian court, for just an example, municipal courts do apply international law legal principles or international law to interpret and determine the content of municipal law. For example, Vishakha versus State of Rajasthan, which you studied in your public international law, wherein in the absence of a sexual harassment against women in workplace law, you did have the court relied on the CEDAW provision, Convention on Elimination of Discrimination Against Women, and tried to formulate, fill the lacuna of law in India. So what we find is that there is a constant interaction. Now, this constant interaction is not just international law being applied by being used to interpret constitution, but rather the constitutions. Constitutional features are also being reflected in international law. Now, for example, many of the international legal organizations are developing frameworks that sort of are delivering constitutional or at least quasi-constitutional functions. Now, for example, World Trade Organization. World Trade Organization is considered to be an economic charter of the world, and it has a written text which governs it. It has a dispute adjudicatory body, and there are certain principles which are considered intrinsic to those to World Trade Organization. Many people also say or also argue or describe UN Charter to be the constitution of international community. There are certain rights which become compelling and binding in international law. For example, jus cogens, which you studied in international law, something from which no derogation is possible, etc., etc. So what we find is that many of the international legal principles have become as intrinsic to legal conversations that happen municipally as are municipal legal features. So that is how this entire process of trans-constitutionalism is emerging, wherein it is even not only the is that municipal laws are being impacted by international legal obligations, but international law is also structuring itself according to or it's constitutionalizing itself and facilitating the trend wherein the manner in which constitutional frameworks operate is the same. It is trying to replicate the constitutional framework even in international law. So that is what transnational constitutionalism is about. The reason why transnational constitutionalism has emerged is because, obviously, because of it is driven by globalization. Because initially, when we had the nation, we still have a nation-state model, but nation-state models, when there was not as much interaction as there is today between different states, and where different states were not so dependent on each other, it was all right to confine yourself within your own territory and the idea of constitution and constitutionalism to be much more confined within your own territory. But as we globalize and as we keep interacting with each other more and more, not that the boundaries of nation state are diluting or withering away, but the process of constitutionalism, not constitution, but constitutionalism is not just happening within the boundaries of nation state, but it is also moving beyond nation states and serving institutional functions at international and transnational levels. So this is what you need to understand by transnational constitutionalism. The only reason why I have introduced to you, just let me give you one example. For example, EU constitutional treaty. Okay, it is one of the most. It is, I think, one of the best examples how constitutional enactment can happen across national borders. Like something like a regional organization, which is a supranational organization, and a constitutional making process is launched, wherein a constitution for Europe attempt was made to formulate a constitution for Europe. An attempt was made there. So what we find is that constitutional law, the idea of constitutionalism is also expanding its scope and entering into the domain which was ideally reserved for international law. And there is an overlap which is called by the name of transnational constitutionalism. So this is, I just wanted to discuss this concept because once you study about constitutionalism, you may come across these terms. Not that we will be studying or discussing transnational constitutionalism at all, but you must be aware of these terms. So let me know if you have any confusion understanding this. Okay, there is a question. Monarch and authoritarian form of government does not also have constitutionalism. Not necessarily, Basant. You have UK, which is an example of monarchy, right? But you still have constitution and constitutionalism there. So it is not necessary that monarchy would not have constitutionalism. So it is. So democracy is not the only form of government which has constitutionalism. There can be other forms of government which has constitutionalism. Yes, you may question whether autocracy will have a form of constitutionalism. No. Authoritarian form of government will have constitutionalism, at least not because the very idea authoritarian government means that there is no limitation on the power of the government. So maybe not. Authoritarian regime may be a contradiction in terms with constitutionalism, but not necessarily monarchy. Monarchy may not necessarily be a contradiction with constitutionalism. You have to understand monarchy is not essentially bad all the time. It all depends on whether you have a benevolent monarch or not. And the same goes for democracy as well. It all depends on the kind of elected government and whether the electoral processes and democratic processes are being followed fairly and impartially or not. That will determine whether democracy is actually a democracy or not, and it's not an authoritarian regime. We find developments across the globe wherein we have democracies are gradually converting themselves into authoritarian regimes, and that is a development that is happening across the globe. And in the same manner, monarchy need not always be against constitutionalism. There are instances where democracy may be against constitutionalism. But yes, I would agree to you to the extent that authoritarian form of government does not necessarily coincide with the idea of constitutionalism, because the term authoritarian in itself means that the government has excessive power, and the power is not limited. Where the where the rules are enforced at the cost of personal freedoms and rights. So, to that extent, but not necessarily monarchy. Okay. Any other questions? Fine. So I hope the discussion till today was clear to you. Obviously, if you have some confusions, you can ask. And anyway, all these concepts will get clearer and clearer as we move ahead in constitutional law. Now, because we have only a few minutes left, what I will do is that instead of completely discussing another topic, I will just open the next topic that we are going to discuss before you. That is the topic of federalism. Now we are going through these concepts because you need to understand these concepts before we even venture into discussion of at least go into the text of the Indian Constitution. So what do you? I would like to have a response from all of you. What do you understand by federalism? Yes, someone.
States also having power.
Okay, fine. Anyone else? You'd like to explain what is federalism?
Distribution of power.
Between whom? Distribution of power between whom?
Between state and
Center and state.
Okay, fine. Now, federalism is a model. Federalism is a model wherein different constituent units of state, or the manner in which different constituent units of state are organized, as in there is distribution of power between different constituent units of a state. And when I say state here, I mean country. Okay, that is how I'm using state, not state as in UP, MP, or Kerala, not in that sense, but as a country. Now, when I say so federalism is basically a concept about how constituent units of a state have organized themselves and what is the kind of power distribution between constituent unit of the state. Now, there are different forms of federalism which we find across the globe. But one of the basic feature of federalism is that there must be some kind of demarcation of jurisdictions among the constituents of a state. Okay, so one of the basic features of federalism that we talks about demarcated jurisdiction. And the reason why demarcated jurisdiction, the jurisdictions are demarcated so that governmental authority can be exercised in a more meaningful and a much more convenient manner. So one of the starting point for any discussion on federalism is that federalism talks about demarcating the authority or the jurisdiction between different constituent units of a state. And how is that demarcation done? That demarcation is done in a manner that each unit is autonomous from the other. Okay. So, how do we understand federalism if you have to understand it? Two important, we are not even going, so what Finesse as power of states can't be suppressed by union. Okay, we are not even going into different models of federalism because maybe your question or your comment would better find a place when we are discussing different models of federalism. Let's first understand what is it that we mean by federalism essentially. Okay, essentially federalism talks about demarcation of jurisdictions or power between different constituent units of a state and demarcation of jurisdiction or power in a manner that each constituent unit is autonomous as compared to the other, and autonomous from the other. Now, if you look at different models of federalism, or at least try not to confuse distribution of power and jurisdiction with distribution and power and jurisdiction between different wings of the government or different kind of institution. So let's say the distribution of power between executive, legislature, and judiciary is not federalism. Okay, that is not federalism. What federalism is about? Federalism is about the demarcation of jurisdiction and distribution of power between the constituent units of a state. So let's say in India, union government and the state government. So how the power is distributed between union and the states in India, and how the power is distributed and how autonomous are state and union from each other, and how autonomous are states vis-a-vis each other. That is what federalism is per se about. Now, there are several models of federalism. The most popular one is the model of classical federalism. Now, classical federalism is a model that is followed in the United States. What does classical federal model mean? Classical federal model means that independent states come together to form a union, which happened in United States, right? So several independent states, they came together to form a union. So that's why when we talk about so that's why states in United States, or at least different provinces, they use the term provinces, or states in United States, have much more freedom and autonomy as compared to, let's say, states in India. Because India is not an example of classical federal model. Because in India, different states did not come together to form a union. Rather, a union was formed, and subsequently different states were carved out of that union. Okay, so but one of the most initial models of federalism is a classical federal model, wherein different individual units constituted a federal government. Different individual units constitute a federal government by yielding power to the union government. But India is not an example of federalism. But however, that does not mean that the only kind of federalism that can exist in the world is classical federal model. We have examples of several forms of federalism, including that of India, wherein there is some sort of distribution of power between the constituent units, and there is some kind of autonomy that is asserted and exercised by those constituent units. So that's why even India is considered to be a federal nation, irrespective of the fact that it is not close to the kind of federalism that is followed in the United States. So that is where I would like to stop here, because subsequent discussion on federalism would require, because if I invoke another